Hey ladies, please like the video and give me a comment with regard to this interesting article that I found here. This gentleman is saying, I am an employment attorney who rejects 98% of inquiries. Here are the wrongful termination cases that actually stand a chance. Again, thought this was interesting. This guy, Jonathan Pollard, is an employment attorney. He receives hundreds of inquiries. He writes that most employees with grievances are entitled, dramatic, and looking for a payday. Pollard writes that most people who reach out have absolutely no case. So we're going to read through this article and see who has a case, who doesn't, so that you are able to protect yourself as an employee. So again, he owns a law firm in Fort Lauderdale, Miami, and shortly in St. Louis, Missouri. These days, most of our work involves representing employees in pursuing cases against corporate America for discrimination, sexual harassment, sexual assault, and retaliation. He's saying here that he believes in the work. There are very real instances of corporate America engaging in misconduct, and they aggressively pursue those real cases. However, he feels that a lot of employees with workplace grievances are entitled, dramatic, maladjusted, delusional, and just looking for a payday. So again, 98% he throws out, 2% he keeps. He's saying here 75% are clearly frivolous and there is no case. 20% are plausible cases that he does not pursue due to a lack of evidence or unfavorable law. And then 5% are real cases. And of those real cases, he only takes 2 to 3%. And of course, these are the ones, the 20% that are plausible, but he doesn't pursue due to lack of evidence or unfavorable law. Those are the ones that really kind of, concern us. And we want to make sure that we are getting the evidence that we need. Again, check out Mentor Shelley. She is the one that handles all of this information for us and with us. However, I thought this was an interesting article. So the frivolous cases, most people who reach out have no case. So people who feel that someone was mean to them at work, they were fired and don't like the reason why, they think they did a good job or at least a not fireable job. They were never given a final warning. Nobody owes you a final warning, ladies. They don't feel valued or validated. These people feel like their situation is terribly unfair and hurtful. In these types of cases, the details may change, but the general story is always the same. Company X recruited Fred and promised him the world, not in writing, of course. The company never trained Fred on key responsibilities. The company threw Fred to the wolves and made him figure things out on his own. Fred did his best, but his direct boss never empowered him. Fred's voice and opinions were not heard and validated. Fred was terminated and his feelings are hurt. Modern society has convinced people that feelings and rights are interchangeable, but that is not true. Laws exist to protect rights, not feelings. So, ladies, I do want to talk about one thing here, and this is about training. If you feel like you are not being trained properly and you're not being trained on key responsibilities, I definitely suggest that you put it in writing. I also suggest that you speak about it with your boss and your boss's boss. You ask for money to go towards training. For example, I went back to my company and asked for additional money within my training budget because of some of the lack of training that I have now, and they have said yes to me. So do not be shy. If you need additional training, go and request it in writing as well as verbally. Okay? Because if you request additional training in writing and they still don't do it and they still brush you off, then you have a greater chance of having a suit. So, all right. Again, get everything in writing. Number 2, performance improvement plans. People who receive critical feedback or were put on a PIP. Getting off a PIP is extremely hard. We had that conversation before on this channel. But it says here, some people are aggrieved solely because a company has given them critical feedback on their performance. These people have no concrete allegations of discrimination, retaliation, or other corporate misconduct, but they have been fired, given a negative performance review, or have been placed on a PIP, which is Performance Improvement Plan. So, you have no legal action. You have no legal action with regards to that. Some people have viable cases, but they are not worth pursuing. These, again, are our plausible people. Plausible cases involve a situation where something seems improper, but there is no compelling direct evidence and or law on that specific situation, which is not favorable to them. These are cases where the employee might have a viable case, but not a case that is strong enough for the attorneys to pursue. So the real cases, again, a small percentage are from people who clearly have been legally wronged and they can prove it, ladies. They've got documentation. So this is 5% here. Again, discrimination, retaliation, sexual harassment, sexual assault, defamation. The potential clients are good, solid people who seem reasonable and honest. I think they need to seem reasonable and honest because oftentimes they have to be persuasive to a jury. So even though a lot of these cases are mostly settled out of court, I believe most of these cases are settled out of court. If the person seems reasonable and honest and you put them in front of a jury, then the corporation would get really nervous about that. So it's also saying here, at their jobs, they have been treated in a manner that is morally and legally wrong, inhumane, and sometimes utterly horrific. Still, he's saying here, we do not take all these cases because of economic realities. Small companies that engage in the worst forms of misconduct do not have sufficient assets or insurance. A $10 million judgment is worthless unless you can collect. So if you work for a small company, they will still potentially say no to you. He's saying here he's chased big judgments through layers of shell companies, but he does not do that anymore. This is reality. It is not his job to play nursemaid to the universe and tilt at windmills. So basically, this guy is choosing the 2% of cases that he can win. So if the company is too small, or sometimes if the company is too big, it's a holding company, things like that, you have to pierce corporate veils and all of that. It can be very difficult. So the cases that he accepts: race discrimination, particularly against Black people; age discrimination, particularly against people 60 years and older; sexual harassment or outright sexual assault. Many of these cases also have a retaliation component. So some of the ugliest cases that they've seen come out of the broader construction industry. Workers constantly called the N-word and told that they would be unalived if it was still the good old days. Construction foreman riding around on his golf cart, gun strapped to his waist, shouting racial slurs at Black workers digging in a trench. Rampant sexual harassment and sexual assault. Women, RAPED, by a coworker on a job site. So still have your documentation, ladies. And in these real cases where we represent good people who have basically been beaten down and abused, we will go to the ends of the earth to vindicate their rights. So this is what this lawyer is saying here. Sorry, I can't speak now. And I thought this was a very interesting article, so I wanted to share it with you. You can keep it in your back pocket, keep the information in your back pocket as well, in case you ever need it. So that is it. I will see you in the next video.